Good day, everyone. I'm Greazzel Jade Masadia, and I'll be reporting one of the articles of Chapter 8 Unenforceable Contracts, and my group mates are as follows. So let's start with the meaning of unenforceable contracts. Unenforceable contracts are those that cannot be enforced or given effect in a court of law or sued upon by reason of certain defects provided by law until and unless they are ratified according to law. So, when a contract is unenforceable, it means that it has certain legal faults that prevent it from being enforced or given effect in court. So, next is binding force of unenforceable contracts. While resistable and voidable contracts are valid and enforceable unless they are rescinded or annulled, Unenforceable, unenforceable contracts, although valid, are unenforceable in court unless they are cured or ratified. Once ratified, these contracts may then be enforceable. Article 1403. The following contracts are unenforceable unless they are ratified. First, those entered into the name of another person by one who has been given no authority or legal representation or who has acted beyond his powers. So these are the contracts that are unauthorized. You're selling the property even though you don't have the authority. For example, A representing himself as an agent of B sold B's land to B. So basically, in this example, A is transacting with B, but A is representing B, the owner of the land. A is only the agent of B, so the one that is transacting legally with B is B. The question here is A authorized to transact with B? If it is unauthorized, the contract between A and B is unenforceable. Neither A nor B can demand anything between, can demand anything from each other if B did not authorize A to sell or transact his land. But there is an exception. When P ratifies the sale, it will become perfectly valid, so this agreement may then be enforceable because P ratified it. Next is those that do not comply with the statute of frauds. When we say statute of frauds, this is a law that requires certain types of contracts to be made in writing and signed by the parties. The purpose of statute of frauds is to prevent fraud and misunderstandings by ensuring the parties have a written record of the terms they agreed to. So contracts must be made in writing and signed by the parties to avoid being unenforceable. But the exception here is when unenforceable contracts are partially executed. In these following cases, an agreement hereafter made shall be unenforceable by action unless the same, or some note or memorandum thereof be in writing and subscribed by the party charged or by his agent. Evidence, therefore, of the agreement cannot be received without the writing or a secondary evidence of its contents. So the first agreement is agreement not to be performed within 1 year from the making thereof. Example, X and Y verbally agreed to form a partnership after 13 months, so X refused and it is justifiable because they only agreed verbally. So this case is unenforceable. Second, promise to answer for the debt, default, or miscarriage of another. Example, D is indebted to C. G orally guaranteed this debt, but C can't demand payment from D because it was entered orally. So, this is unenforceable. Third, agreement in consideration of marriage other than a mutual promise to marry. Example, Z orally obliged himself to give X a piece of land if X marries his daughter Y. Y did X did marry Y, so Y asked Z, the father of Y, about the land he promised to give. But Z refuses to give X the land because the contract is only oral. Fourth, agreement for sales of goods, etc. at a price not less than 500 pesos. Example, S and B mutually promised to sell and buy a piano at a price of 12,000 pesos. This contract must be in writing to be enforceable against either party, but if it is delivered or has a partial or full payment, it is partially executed or perfectly valid. Fifth, agreement for leasing for longer period than 1 year. Example, R agreed to lease his house to A for 2 years. This agreement must appear in writing to be enforceable unless it is partially executed. 6. Agreement for the sale of real property of an interest therein. So, regardless of the price needed, the contract must be in writing to be enforceable. 7. Representation as to the credit of a third person. Example, A. An insolvent person is in need of cash, so A asks B for help. B orally represented A as having good credit to C, who extends a loan to A because of B's representation. Later on, C can demand payment from A because A is insolvent. C C has the right of action against B because B represents A. This is but this is orally only. So this example is unenforceable unless ratified. So this 7 agreement is under statute of frauds. So the last unenforceable contract under Article 1403 is those where both parties are incapable of giving consent to a contract. So both parties are incapacitated. So when we say incapable or incapacitated, it is unable to do something. For example, a minor. For example, a minor, sold his skateboard to B, a minor. This is unenforceable because both parties are minor and incapable of what they did. But the exception here is if both parents of B of A and B ratifies it. That's all.
Good day everyone, my name is Kimerly. I'll be continuing right now the discussion of the chapter 8, which is the Unenforceable Contracts. So the topic or the article that has been given to me is the article 1404 together with the article 1405. So let me discuss first the article 1404. So Article 1404 talks about unauthorized contracts that are being governed by the Article 1317 and the principle of the agency and this title X of this book. So as we all know, we have already heard or we have already discussed the Article 1317 by the previous group. It was already discussed by the previous group, but since it was being included on the Article 1404, let me reiterate again how this Article 1317 works. So Article 1317, it talks about no one may contract in the name of the other without being authorized by the latter or unless he has by law or he has the legal representation. So let me provide an example of unauthorized contracts. So for example, my brother sold my car to his friend without my permission or consent. So this kind of example, we can consider this as an authorized contracts. So he takes an action with himself without the legal permission of mine. So we can consider this as an authorized contract. So as we all know, an authorized transactions involves legal consequences. So let's move forward right now with the Article 1405. So Article 1405, it talks about contracts infringing the statute of frauds referred into a number 2 Article 1403 or ratified by the failure to object to the presentation of oral evidence to prove the same or by the acceptance of benefits under them. So there are 2 modes of ratification under the statute. So the first is the failure to object to the presentation of oral evidence to prove the contract. The failure to object amounts to a waiver and makes the contract as binding as if it has been reduced to writing. The requirement of a written form is for evidential purposes only. So, for example, if parties entered into a verbal agreement to sell goods and one party later introduces oral evidence in the court to prove the terms of the agreement, if the other party fails to object to the use of oral evidence, it may be deemed a waiver. Consequently, the court might treat the verbal contract as binding to a written agreement. So let's move forward right now with the second one. For the second one, we have the acceptance of benefits under the contract. In this case, the contract is no longer executory and therefore the statute does not apply. This rule is based upon the familiar principle that one who has enjoyed the benefits of a transaction should not be allowed to repudiate its burden. So a perfect example for this one is, imagine 2 parties verbally agree on a landscaping contract for one party to maintain the other's garden. If the landscaper begins to work and the homeowner accepts and enjoys the benefit of a well-kept garden without objection, the homeowner may not later use the lack of a written contract to repudiate the landscaper's services based on the principle that accepting the benefits implies acceptance of the agreement. So that would be all for the Article 1405. Thank you so much.
And then for our next topic which is the Article 1406. So 1406 here, when the contract is enforceable under the statute of frauds, the public document is necessary for its registration in the registry of debts. So the parties may be avail themselves in the right under Article 1357. So in this Article 1406, so every time you're having a agreement, all you need to have a document or any paper in order to have a reference, because if your agreement only orally or verbally, the contract will be void. So if you're having a agreement, you need to have any special form in order the contract will be perfected. So for example, other party orally sell his real property, so that contract cannot be compelled to put the contract in the public of documented, because for the purpose of registration, it is unenforceable. Which is the Article 1407. So in this article, in the contract where both parties are incapable of giving consents, express or implied ratification by the parents or guardian, as the case may be, one of the contracting parties shall be give the contract the same effect as if only one of them were incapacitated. If ratification is made by the parents or guardian, as the case may be, one of both contracting parties or contract shall be validated from the exception. So in this Article 1407, for example, girl is 15 years old while the boy is 16 years old, we're getting married at the same age. So this both parties is incapacitated because they're still minor. So this where both parties are incapable of giving consent, the contract is unenforceable. So however, if the parents or guardian, as the maybe of either party or one of the parties, after retaining and attaining the capacity, ratifies the contract, it becomes a voidable.
Article 1408. Unenforceable contracts cannot be assailed by a third person. Right of the third person to assail an enforceable contract. Strangers to avoidable contract cannot bring an action to annul the same. Neither can they assail a contract because of its unenforceability. The benefit of that can only be claimed or waived by one who is party or privy to the oral contract, not by a stranger. Appeals 97 Phil 965, an action for restriction by be brought by a third person. Meaning strangers cannot question or assail the unenforceable contract. Hindi siya pwede makat sa stranger or hindi nadala sa kontrata. For example, nagbebenta si S ng isang parsela ng lupa kay B. Ang kontrata ay pasalita. Itinatali ni C ang kanyang sarili sa pagsulat para sa pagganap ni B ng kanyang obligasyon. Sa isang aksyon ng S upang mabawi ang presyo ng pagbibili, hindi maaaring tumanggi si C na ang kontrata sa pagitan ng S at B ay hindi maipapatupad sa ilalim ng batas ng mga pandaraya. Si C ay isang estranghero sa kontrata.